our listeners and viewers around the country and around the world. In an historic ruling Thursday, the Supreme Court voted that the Second Amendment enshrines the constitutional right of an individual to own and keep a loaded handgun at home for purposes of self-defense. The 5-4 decision to overturn the 32-year-old ban on handguns in the nation's capital is the court's most significant ruling on the Second Amendment since 1939. In his majority opinion, Justice Scalia said that, quote, the right of the people to keep and bear arms, as enshrined in the Second Amendment, applied not only to the well-regulated militia mentioned in the amendment, but also to individuals. He added, quote, it is not the role of this court to pronounce the Second Amendment extinct. The dissenting justices strongly disagreed and called the decision, quote, a dramatic upheaval in the law. Justice Breyer wrote, quote, the decision threatens to throw into doubt the constitutionality of gun laws throughout the United States.
President Bush welcomed the ruling, as did Senator John McCain and Senator Barack Obama. The National Rifle Association applauded the ruling and said it marked, quote, a great moment in American history. The Brady Center to Prevent Gun Violence criticized the decision and argued it would, quote, embolden criminal defendants and ideological extremists to file new legal attacks on existing gun laws. The rulings also met with widespread criticism from lawmakers and the mayors of Washington, D.C. and Chicago. Congressmember Eleanor Holmes Norton represents the District of Columbia. She's speaking out about the decision, joining us from Washington, D.C. Welcome to Democracy Now!
Good morning, Amy.
It's great to have you with us. Can you start by just responding to this ruling?
The ruling is, I suppose, has really very bad news and very good news. The good news is, for those of us who expected the worst, it could have been worse. First of all, it was narrow, 5-4, and its wording left a lot of room still to regulate guns, because the ruling's holding amounts to three things. You can have a handgun in your home to be used only for self-defense. That means people shouldn't go out and think they can have a gun and shoot it, because if you were to shoot it and it were not used for self-defense, for example, it would not come under the court's decision. Moreover, it doesn't mean there is an individual right to have a gun. It's an individual right to have a handgun in your home and used for self-defense. It could have been worse. The bad news is that no handgun in your home is going to remain in your home. These handguns are going to, first of all, handguns in the home, according to all the data, are used primarily for suicides and for domestic and friend-to-friend violence. They are used, or not particularly used, but cause huge accidents among grown-ups and children. Imagine people sitting in their houses getting a jump on a criminal. Most of the criminals in the District of Columbia do not enter houses when they think people are at home in the first place. So in many ways, the decision was a huge stretch. It was a stretch around the Second Amendment itself, because the Second Amendment starts saying exactly what it's about. It was about a country that was very afraid that creating a central government, which would have an army, would leave the states disempowered to, in fact, handle themselves. And so the states were assured that these militias could always be armed. This court, which calls itself a conservative, strict constructionist court, simply reached around that, called it a preamble, and said that the use of the words militia and people was about individual rights, when if you look at all of the amendments of the Constitution, 6 other amendments, when the word people is used, it is referring collectively usually to the states.
Well, Congresswoman Holmes Norton, unfortunately, both political parties, it appears, as well as the two top presidential candidates, have essentially, in their platforms and in their pronouncements, supported the court's interpretation, apparently.
Certainly not the court's interpretation. Both political parties, I don't know what you mean by political parties. I wasn't aware there was anything in the Democratic platform about the Second Amendment. But I can say to you that the district gun law was consistent with the Second Amendment. There was the right to have a gun in your home. It had to be unloaded. It had to be a gun used for hunting. Even we, with the strictest gun laws, have never taken the position that an individual couldn't own a gun. What, in fact, the radicals, the gun radicals are saying is that, indeed, there should be no regulation and that the Second Amendment is like the First Amendment. It should be absolute or near absolute. At least the court said it wasn't absolute. And if the district is doing its homework, as I can assure you it is, it will now proceed to write very, very strict gun laws, which I think can be done consistent with this decision.
Did those state that it allowed states and jurisdictions to continue to have restrictions or regulations for the sale and possession of handguns, correct?
Yeah, that's a very important question. Yes, for example, it said that the licensing requirements, registration requirements could in fact be used so that